Hello and welcome to Move or Improve with Debbie Miller. I'm Debbie Miller and thank you for joining me today. I am very fortunate to have an attorney who is well versed in the issues surrounding estate planning, and I asked her to join me today because I want to cover the problems that people have as to why they don't want to have a will or do any estate planning, and why they think writing it on the back of a paper napkin is okay or doing it online is okay, and the mistakes that people make. So Melinda Merk is an attorney with McCandlish Lillard, and she is going to be answering a lot of questions that will hopefully give you an insight as to what you should be doing. She is very proficient in this field because the one thing I liked about her was she works with not only estate planning, but she has a background in a tax administration and in working with wealth management in the big banks. So she really has a lot of good information to share with us. And welcome to the show, Melinda. Thank you for joining me.
Thank you for having me, Debbie.
So let's start off first by I was surprised to discover that a lot of people don't even have an estate plan. So why do you think that is?
Yeah, you and I sent you the annual survey that's done by caring.com, which you can Google, and the statistics are quite telling. As of the end of 2019, they surveyed over 2,400 people, and the survey indicated that although 60% of the people thought that estate planning and in particular having a will was important, only 32% of people surveyed said they actually had a will. And this unfortunately had declined from prior years, where in 2017, 42% of those surveyed said they had a will. And when we break it down further by age group, certainly fortunately, the folks 55 years old and older, they have done more estate planning. In 2019, from last year's survey, 60% of those 55 years and older said they have a will, but that has declined as well in the most recent survey done for 2020. Now it's down to less than half of the people surveyed, 47.9% say they have a will. And so the other statistic I wanted to share from this survey is that they asked, so you say, 60% say they think estate planning and having a will is important, but what are the reasons why you don't have a will and some of the barriers? And not surprisingly, the most common reason was, I'm just too busy. I haven't gotten around to it. Other reasons were, I don't have enough assets that I need, to leave to anyone that I would need to have a will. That the cost and, that it's too expensive to set up a will was also given as a reason. And then also, I just don't know how to go about it, and it's confusing. I don't want to think about it. And other reasons that I have heard, which I tend to not let clients get away with as much anymore, is, what do I care? I'm not going to be around to deal with it. And, that's really the worst excuse, because then it's your family members who are left to deal with it.
It's a little selfish, I think. Yeah. But people, maybe they think they're too intimidated, like you said, or it's overwhelming, but what are the important parts of an estate plan? I mean, it can't be that difficult to break down into segments.
Yeah, and I think it's interesting, the caring.com survey does focus mainly on the question of, do you have a will? And so when I speak with clients, I try to emphasize, yes, having a will is important. That's what controls and how you can, control how you want your assets to pass at your death. But the other important and even more critical documents to have in place are documents that control what happens, when you're still alive. And if you, lose capacity to manage your own financial affairs, so having a durable general power of attorney to appoint an agent to be able to step in, access your bank accounts, pay your bills in the event that you don't have capacity, with us all living longer and the prevalence of Alzheimer's and dementia. That's an extremely important document to have. Again, with regard to very important decisions to be made while you are still alive. And then the other important document is the Advanced Medical Directive and Durable Healthcare Power of Attorney, where you can set forth your wishes with regard to end of life and other healthcare decisions if you're not able to give your own informed consent, and then you appoint a healthcare agent to carry out those wishes, on your behalf.
So what happens if somebody doesn't bother to prepare a plan? Like you said, they just say, well, I don't want to be, I'm not going to be around. Who cares? What happens?
Yeah, I mean, we are seeing more and more, again, situations where the person is still living. Oftentimes they still live at home by themselves. They may or may not have children. They slip and fall, and they're in the hospital, and then rehab, and get out, and then are discharged and sent home. And they don't have the ability to, get to the bank, or, what if the house has to be sold because they need to move to assisted living? And, just because either of their physical disabilities or if they don't have the mental capacity, they're really stuck at that point. And then, if they do have children or other family members, that's when you're in crisis planning mode. And then we hear from the family members, asking us for help. What can we do? And at that point, unfortunately, if the client does not have a power of attorney in place, you're looking at going to court and filing a petition to have the family member appointed as the guardian, so that they can then access the bank accounts, pay bills, and make healthcare decisions, hire home health care, that sort of thing. So guardianship proceeding is very time consuming. It takes several months and several $1,000s of legal fees and court costs. And it is it's a public proceeding. You are subjected to a medical evaluation, and it's all public record. And then once a guardian is appointed for you, typically you lose your right to vote and you lose your driver's license. So it's a very burdensome process. Again, this is while you're still alive. If you die without a will, similarly, your family members or other, beneficiaries are forced to go to the court because your assets are essentially frozen at death. And the only way to access those assets to, again, pay your final bills, pay the funeral home, make other arrangements, and then distribute the assets to the heirs at law, who is decided under the state intestacy laws. So the state decides who of your heirs, how your money is distributed. And similar to the guardianship proceeding, probate is very time consuming, very expensive, and can take at least 6 months to a year to complete.
It's very time consuming, and it's something that can be avoided. I think that's what's so annoying, is that people can avoid all this, even though they're not going to be around. Why put your heirs through this. What are some of the other biggest mistakes that people make? Like, do they? I've heard people that forget to sign a document, or they don't get it witnessed, that sort of thing. What are some big mistakes that people make?
Yes, it's in my experience, doing it yourself is almost worse than doing nothing because again, people understand that, having a will and these other documents is important. And so, but because of those barriers we discussed, they figure, I'll just go, download a form from the internet. I've got it covered. And, they don't properly execute the documents by, signing them in front of a notary. They don't get the requisite witnesses. But they think, I've got it covered. And then again, later down the road, if they have a stroke and lose capacity and their children actually then go to the bank and try and access and present the power of attorney, the 2-page power of attorney that they've downloaded from the internet, they come to find out that the bank says, sorry, but we can't accept this. And then you're stuck again, having to resort to a court supervised guardianship.
It's just like such a big headache, time consuming for the heirs and the people left behind. But so it doesn't sound like it's the same thing to do, to prepare the estate documents yourself, because you don't know what you don't know. But and I'm assuming that every state's laws are different as far as what they require. So you'd have to know if you're a child living in, like California, and your mother lives in, I don't know, New Jersey or whatever, you can't use California laws to settle the estate. You have to use New Jersey, correct?
Yeah, every state's laws are different, and it is, definitely, oftentimes when we are called in again to try and clean up things, either if the client is, getting out of the hospital and doesn't have capacity, and the children need to step in and pay medical bills and move into assisted living, or at death, when the documentation is not in place. I mean, that's when actually, the family ends up spending more money in legal fees for us to clean things up than if they just would have, taken the time and, gone to an attorney to make sure that the documents were prepared properly, in the beginning.
For sure. Well, some people say, oh, well, I'll just do it online. There's a number of different websites that say, oh, yeah, we'll help you do your will. It'll be just fine. So what are the drawbacks to doing it that way, though?
Yeah, I think there again, you don't know what you don't know. Just like, going to WebMD, and doing an internet search when you don't feel good versus going to a doctor. I heard someone give an analogy that the other day, would you pull your own tooth instead of going to the dentist? So
some people might try that. I don't know.
So, again, you can spend the time doing it and you think that, okay, I've got it covered. And then unfortunately, because of some, state law consideration or requirement that was not included, you and your family are going to be stuck later down the road when you actually, need to use the document.
Yeah,